The first thing the British medical officer noticed inside Bergen-Belsen was the quiet that refused to be silence. It sounded like a hospital corridor at 3 in the morning, and then like a factory cooling after a fire, and then like nothing he could name. He had come with a camera, a notebook, and instructions to weigh everything he saw against the standards of the civilized world. Then he stepped through the gates, and the standards lost their vocabulary. Guards who had once strutted now stood in a line the color of dust, their insignia suddenly weightless on their sleeves. Among them was a young woman whose face visitors would later remark upon because it looked so ordinary in the new light. Irma Grese, SS wardress, 21 years old in April 1945, promoted beyond her age and clinging to a manner that assumed the old world still existed. In photographs taken that week, she does not look monstrous. She looks practiced. That practice, how to command, how to hurt, how to pretend impunity is a credential, had been learned at Auschwitz-Birkenau and brought to Belsen on the last train of a collapsing regime. The camera would not convict her by itself. The law would. And the law's first task was to turn the quiet into facts. The story that reached the courtroom later did not need adjectives to be terrifying. It began in villages and training schools where uniforms fit too well, and ambitions found a set of rules willing to turn cruelty into a job. Grese joined the SS Women's Auxiliary in her teens, not as an outcast seeking sensation, but as a person who believed the structure she was entering would grant her importance. At Ravensbrück, she learned routines. At Auschwitz, she learned power. There, the role of Aufseherin, overseer, was both narrower and more vicious than the word suggests. It involved supervision of women's labor details, enforcement of regulations written to break the body's patience, and participation in selections for the gas chambers that disguised murder as procedure. The camp was a machine with many gears. She was a gear that took pride in not slipping. Witnesses would later remark on the neatness of her appearance, the whip she carried like a resume, the smile that did not always come at the wrong time, because, in that world, cruelty pretended to be the right time. By early 1945, the machine that had rewarded her was seizing. The Soviet advance had pressed Auschwitz into evacuation. Columns and trains moved west carrying prisoners too weak to march, and guards too frightened to admit it. In March, Grese arrived at Belsen, a camp already in freefall, its administration unable to keep up the pretense of order. Disease and starvation were no longer conditions. They were theology. The SS chain of command at Belsen was segregated by rank and role, and its hierarchies were petty as well as lethal. Within that structure, Grese's authority expanded not because she possessed new ranks on paper, but because the everyday tyrannies she practiced brought results the collapsing leadership valued: obedience, fear, the appearance of control. What she did there was not an improvisation, but a grim reprise. A selection here, a beating there, a refusal that betrayed priorities the regime called discipline, and the law would soon call evidence. She moved through a landscape of dying people with the assurance of someone who believed dying people could not speak. They spoke, not immediately, and not all at once. In April, the British arrived to find an open wound on the European map. The liberation of Belsen is sometimes described in superlatives: unprecedented, unimaginable. But the British officers did not have the luxury of poetry. They had checklists: secure the camp, separate the guards, Feed the survivors without killing them by kindness. Photograph everything. List names. Grese was arrested with others and processed like a suspect in an ordinary crime, because that was the point. The Allied decision was to turn a catastrophe into a set of cases. They could have dragged the guards to a wall. Some men in uniform said as much under their breath. Instead, they separated, documented, examined. Military police recorded identifications. Medical personnel performed inspections that made horror visible on paper. Weights, wounds, diseases, the imprint of violence on skin. Photographers made images that would travel into the future. All of this would become a scaffolding for testimony, so that words spoken in a courtroom could stand without collapsing under the weight of what they described. The Belsen Trial convened in Lüneburg, a British military court sitting under the authority of the 1945 Royal Warrant. That document did not invent justice. It arranged it for war. It set out who could be tried, for what, and how. In that room, judges wore uniforms and patience. Prosecutors presented not theatrical speeches, but sequences. This guard, this date range, this authority, these acts, this victim. They established command responsibility where appropriate and individual culpability where necessary. With Grese, the case leaned on patterns. Survivor after survivor described the same presence, the same methods, the same participation in selections and punishments. Some witnesses recognized her from Auschwitz and Birkenau, others from Belsen. A few recognized her from both and brought a continuity the defense could not break. The courtroom's calm felt, to some who watched, like a betrayal of the chaos it was judging. In fact, the calm was the weapon. It permitted corroboration. It permitted contradictions to be explored without being turned into excuses. It permitted the judges to weigh evidence instead of adjectives. Grese's defense resembled others mounted by those who had served in the SS apparatus. I followed orders. I had no choice. I held a title without authority. I am being accused because I wore a uniform. British counsel and the court did not mock these claims, because mocking would have been a loss of focus. They asked facts to do the work. Who issued the orders? What did you know about selections? Where did you stand when a column was marched off to a place from which nobody returned? How often did you carry a whip? How often did your words alter the fate of a prisoner for the worse? Witnesses answered not with speeches but with memories the defense could poke and the prosecution could anchor with documents. When she denied authority, other SS personnel, timid, hedging, not eager to make enemies among the guilty, admitted she wielded it. When she claimed ignorance, transport lists and duty rosters suggested a knowledge that was more than rumor. At crucial moments, survivors across time and site aligned in descriptions hard to dismiss as coincidence: the walk, the voice, the injuries, the roles. The court's method allowed grief to be present without being the only speaker. Photographic evidence did not accuse her specifically of a murder, but it proved the environment in which her authority operated. Medical inspections of survivors and exhumations of mass graves provided context for the acts alleged. To beat or starve a person in a camp, where disease and deprivation defined the baseline, was not a neutral act. It was a lethal one. The Royal Warrant framework drew a line from policy to person. It did not require that a defendant had written the policy. It required that the person had enacted it, knowing its nature. Prosecutors avoided the easy trap of turning Irma Grese into an exotic monster whose crimes belonged to pathology. They portrayed her as an administrator of cruelty within a system designed to make cruelty administrative. That portrait, in the end, is more frightening and more useful. It argues that the ordinary can commit the extraordinary when authority rewards it and impunity protects it, and that a court can withdraw both rewards and protections in public. Trials take time to breathe. From September through November 1945, the Belsen court heard dozens of witnesses. Interpreters worked without rest. Judges kept counsel from wandering into lectures. The public listened with a mix of hunger and nausea. Some had lost family and wanted vengeance disguised as verdict. Others had lost faith and wanted the law to make a speech in their language. The law spoke by asking questions and writing its answers into the record. The courtroom connected to the camps in ways that were both moral and material. Evidence from Auschwitz crossed the threshold because the indictment included offenses there. Evidence from Belsen anchored the particular. The defense's attempts to atomize the case, this incident and not that one, this day and not that day, broke against a wall of consistency. The prosecution did not need to prove every cruelty. It needed to prove enough of them beyond reasonable doubt within the charge framework. It did. On November 17, 1945, the court returned verdicts. Irma Grese was found guilty and sentenced to death. The sentence was not delivered with joy. It was delivered with the formality of an institution that had measured the acts and the law together, and found that the law must be the heavier weight. Appeals were brief and failed. On December 13, 1945, at Hamelin Prison, the British chief executioner Albert Pierrepoint performed his duty with the efficiency that made him famous and controversial. Grese was 22. The number retained the power to shock then and still does for readers who expect monsters to be older. The point of the number is not pity. It is instruction. The system that trained and promoted her matured faster than a person could, and the person chose to match its pace. When the system ended, she discovered that personal responsibility had not been dissolved into policy after all. It had been waiting. What happened to her afterward is obvious. Burial in a prison yard, a name in books, a face in photographs that a certain kind of reader has tried to romanticize and that historians have worked to contextualize. What matters more is what happened to the idea of justice those weeks produced. The Belsen Trial was not the only Allied proceeding, nor was it as international in scope as Nuremberg, but it contained a lesson that has survived the century. Terror can wear an ordinary face and still be named. Evidence can outlast propaganda. A court can be both methodical and moral without letting either swallow the other. Its framework insisted that rank matters but does not exonerate, that proximity to lethal processes is not a coincidence but a factor, and that following orders can fail under cross-examination when orders and acts meet in a light bright enough to reveal intent. Behind these abstractions lie mechanics the public often forgets. Photographs do not organize themselves. Doctors do not guess. Clerks do not craft transcripts by inspiration. British officers who had staggered at Belsen's gates returned to the camp with clipboards after the first shock and treated it like a crime scene. They mapped graves. They measured warehouses. They interviewed prisoners whose strength allowed it and protected those whose strength did not. They separated witnesses to prevent rehearsed stories and brought them together when corroboration would be clean. They made sure the defendants had counsel, because a trial without defense is a performance, and the law distrusts performance. That discipline gave the verdicts their authority. It also gave history its scaffolding. Without it, we would be left with only photographs and rage, and photographs and rage alone cannot teach the next generation how to recognize a system when it begins to rehearse its lines again. The shadow of Auschwitz-Birkenau falls over every paragraph that contains Irma Grese's name. At Birkenau, the rhythms of authority made cruelty feel like compliance, and compliance like virtue. The women's camp, where she served as an Aufseherin and later as a block leader and senior wardress, was a laboratory for habits, inspections that stripped dignity, beatings that established hierarchy, selections that sorted human beings into columns defined by labor and death, survivor testimonies, collected in many languages after the war, agree on traits even when they differ on details. They describe a supervisor who understood the power of proximity, how standing 1 meter closer could turn a command into a threat, and a threat into a blow. Some recall a whip made from cellophane twisted with wire. Others remember a stick, a dog, a certain tone. Memory is a fragile instrument. The law knows this and asks memory to play alongside documents, duty rosters, transfer orders, names written down by German hands because German bureaucracy had taught itself not to blush when writing such things. In combination, the picture is not blurred at the edges, it is sharpened. In March 1945, the transfer to Belsen replaced one horror with another of a different kind. Auschwitz was a machine that pretended to be efficient. Belsen, in its final weeks, was a collapse pretending to be an institution. The camp was flooded with evacuees from the east, its population far beyond design, its food stocks a lie, its water carriers broken. Lice and typhus ruled. The SS Commandant Joseph Kramer requested more supplies in telegrams that read like a man excusing himself to history in advance. Yet within this chaos, the SS system tried to maintain the habits that had defined it. Roll calls, punishments, a distribution of authority that made certain people feel important, while others ceased to feel human. Grese took her role from one stage to the next, without pause. The British would later argue, and the court would accept, that a person who wields power in an environment where death is the foreseeable result is on notice about what her power entails. She did not arrive at Belsen as a nurse in a disaster zone. She arrived as a senior wardress trained to treat prisoners as instruments. British military investigators who began the preliminary casework for the Belsen trial asked a simple question whose answer took weeks. Who is who? The camp register and SS files had been left in disarray by a command that suddenly valued not being identified. Photographers worked through the first days making image after image of staff, each identified in chalk on boards held at the chest. A young woman standing straight for her portrait, a surname written in white, does not look like the terror that survivors described. That is where procedure protects truth. It insists that the same person exists in multiple media, in an image, in a roster, in a testimony. Then the testimonies. Witnesses were interviewed separately, aided by interpreters who balanced speed with accuracy. An investigator learned that a prompt too leading would collapse a witness into saying what she thought the officer wished to hear. A prompt too open would drown the listener in pain. The best interviews found the middle. Dates, places, sequences. They built timelines by hand, then stacked them to see where patterns emerged. Grese appears in those stacks not as an isolated figure, but as a node through which many separate lines pass. The courtroom built its own geography. On one wall, a large plan of Belsen. On another, a plan of Auschwitz-Birkenau's women's compound. Judges could point to a barracks, an infirmary, a gate, and ask a witness to place herself there in her memory. When two witnesses who had never met and came from different nationalities pointed to the same corridor or gatehouse, the map did some of the convicting. Grese's name attached repeatedly to those points. The prosecution did not claim omniscience. It offered a subset of incidents representative of a pattern that, once established, made it reasonable to believe that other uncharged acts were not inventions. The defense tried to carve the map into unrelated rooms. Perhaps this beating happened, but not under her authority. Perhaps this selection occurred, but she was merely present. The court weighed proximity, role, and context. The Royal Warrant permitted conviction where an accused had participated in ill treatment or had been responsible for prisoners under her authority who suffered it. Responsibility was not a murky moral idea. It was a position in a chart and a behavior in a place. Cross-examination can be a brutal art, but at Lüneburg it frequently performed a simpler function. It exposed the limits of narratives that had been memorized. When Grese insisted she was only present during selections but never chose, counsel asked who then turned detainees toward one column and not another. When she claimed she had no whip, counsel produced testimony that described it in distinctive detail and questioned her about how cellophane becomes a weapon. When she equivocated, counsel produced an SS seamstress who remembered repairs. When the defense appealed to youth, the prosecution appealed to promotion. Authority at 22 was not an accident. When the defense appealed to fear of superior officers, the prosecution asked whether fear ever prevented her from hurting someone. The answers did not need to be theatrical. They needed to be consistent. Often, they were not. The transcript records, silences, and pauses. Those pauses are history's punctuation marks, and they helped the judges read the story the evidence told. The judges applied the law without using it as a shield. The 1945 Royal Warrant was built for a world that had discovered crimes the old codes did not name precisely. It authorized military courts to try war crimes, to consider both direct acts and participation, and to impose sentences up to death. In Grese's case, it meant the court did not need to reduce Auschwitz and Belsen to a single act of murder committed by a single hand. It could evaluate a pattern of brutal ill treatment, selections conducted under the authority of an SS wardress, and violence that predictably contributed to death in places where death was policy. The defense's refrain, orders, met the doctrine the Royal Warrant imported from the laws of war. Superior orders mitigate only when the act is not manifestly unlawful. Beating prisoners, starving them, choosing them for death, enforcing regulations that presupposed extermination. Manifest. The court said so not in poetry, but in the tone of a ledger that has balanced. Grese's age has always attracted commentary, some of it prurient, some of it meant to shock sympathy into arguments that do not deserve it. The court allowed neither fascination nor disgust to blind it to the only relevant points. Rank, role, acts. That choice is instructive. Societies will always be tempted to explain evil by making its agents exotic, thereby protecting the rest of us from identification. The Belsen Trial's method said something else. The ordinary, when allowed authority within an evil structure and rewarded for cruelty, will often become cruel without needing to be exotic. That is why evidence matters. It refuses the alibi that an unearthly villain committed the deed and insists on a human face, recorded and reachable by law. Grese's calm in the dock did not complicate the case. It clarified it. She was a person whose poise had been trained for a parade ground and was now trying to perform in a courtroom. The parade ground had forgiven her deeds. The courtroom could not. While Lüneburg proceeded, other Allied courts assembled their own grammars of justice. Nuremberg employed an international language. Smaller military courts across occupied Germany and Europe worked in local dialects. Each contributed to a new habit: open trials with stenographers, interpreters, exhibits, and the presumption that posterity would read. The British, who had chosen not to improvise punishments at Belsen, invested in documentation that would survive their departure. Photographic albums were assembled, forensic reports were filed. Lists of the dead and the living were reconciled as best as could be achieved in the ruin. Those boring folders do not get as much attention as the famous photographs. But if you understand how ideas outlast moments, you understand their value. They let the next court teach itself without reinventing the alphabet. The final weeks at Belsen tempted later writers to prefer apocalypse over analysis. Bodies piled, disease spread. The line between neglect and murder blurred into a gradient that did not matter to the dead. But analysis is not disrespect. It can be a form of mourning disciplined enough to be useful. Describing the camp's layout, the chain of command, the ration schedules, and the transport lists does not diminish the horror. It makes the horror visible to minds that have never lacked for food. In that framework, Irma Grese's actions stop being a rumor and become a sequence that can be understood and judged. She enforced roll calls that kept sick prisoners on their feet past endurance. She beat women who did not meet labor quotas that no healthy person could have met in those conditions. She stood in places where selections happened and did not treat them as crimes. These sentences are not poetry and do not intend to be. They are the kind of sentences that build verdicts. The day of sentence at Hamelin closed a loop that had started years earlier in classrooms where ideology was taught as vocation. Albert Pierrepoint, who executed the majority of death sentences in the British zones, practiced a method that minimized suffering and left the event devoid of spectacle. There were no crowds, no speeches, no improvisations. The British prison service ran on the belief that the state's most terrible power must be exercised without drama. Witnesses signed papers. A doctor made a pronouncement. Records were filed. If the law had required theater to take revenge, it would have failed the test it had set for itself. Instead, it performed a ritual that marked the difference between camps and courts with an exacting line. After verdict and sentence, a certain species of myth took root. Some tried to turn Grese into a symbol of female depravity to be savored with puritanical thrill. Others tried to make her a martyr to Victor's justice by refusing to read the transcripts. The proper antidote to both is the dull majesty of the record. In it, survivors are not props. They are witnesses, variable and human, contradicting each other sometimes, and still managing to produce a picture that any honest reader will recognize. In it, defendants are not cartoons. They are asked questions and are given space to answer, often to their own detriment. In it, judges are not gods. They are men who put on uniforms and borrowed the gravity of the law to carry them through an era that despised gravity. The record is not entertainment. It is a rope thrown backward in time so the present can pull itself toward understanding. To understand why the court's approach mattered beyond one defendant, consider how following orders breaks under light. The claim is not trivial. Militaries depend on obedience. But the law draws a distinction between discipline and complicity. Obedience ends where crime begins. In camps where death was the baseline, where roll calls and selections were tools of killing, a person who enforced them with zeal cannot claim to have been neutral. Even a reluctant guard would have been required by morality to resist. Greece was not reluctant. Witnesses and co-workers described initiative rewarded by promotion. That is why the sentence could be severe without being vengeful. Proportionality does not mean softness. It means the punishment speaks the same language as the crime: public, recorded, sober. There is a temptation in retrospective storytelling to imagine a single hinge on which justice turned, one brave witness, one damning document. The Belsen Trial, like most human undertakings that work, turned on many small hinges. An interpreter who caught a nuance before it escaped. A clerk who cross-referenced a transport list with a roll book and found a name that made two testimonies connect. A judge who asked an extra question about a date. A doctor who measured a bruise pattern and ruled out accident. A photographer who stepped to the left to include a guard tower in frame. These details do not make headlines. They make history. And they are why Irma Grese's reign ended not in rumor or revenge, but in a judgment that could be appealed, cited, and taught. Belsen's liberation photographs have been imitated, misused, and sometimes doubted by people who prefer conspiracy to comprehension. In the trial, they served a narrower, more powerful role, not as stand-ins for proof of a specific charge, but as anchors for reality. Jurists call this judicial notice. The court accepts that a general fact is true without requiring proof in every case. The photographs demonstrated the camp's condition. Medical reports demonstrated the causes. Within that context, the acts attributed to Grese acquired legal meaning. They were not isolated incidents in a healthy environment. They were torques applied to a body already forced toward death. That is why context is not an excuse at trial. It is a multiplier of responsibility. When the judges rose and the trial's transcript closed, life did not become simple for the survivors whose testimony had helped convict. Some were asked to testify again at other proceedings. Some emigrated and learned that justice does not annul memory. It organizes it. Some found that saying the words on the stand made sleep harder for a season, and then, later, a little easier. Some refused to speak in public ever again because they had spoken once and decided that was enough. The point of a trial is not to heal all wounds. It is to set a public fact in place around which healing is possible if a person chooses it. In this sense, the verdict against Irma Grese erected a factual scaffold in the middle of a world anxious to demolish scaffolds and declare the building finished. Outside the courtroom, Allied policy crafted a larger structure in which Belsen and other trials fit. Open proceedings, records stored for scholars, press access managed but not muzzled, translators employed even when budgets groaned. All of these choices created a tradition of accountability that later courts, from the Balkans to Africa, would inherit. It is fashionable to dismiss such proceedings as victor's justice. The phrase only applies when the victor refuses standards. Here, the standards were written down in advance, applied in open session, and articulated in reasoned judgments. A defendant could read and be read. That is not the justice of a victor alone. That is justice behaving as if it expects to be judged also. The final chapter of Irma Grese's life is shorter than the damage she helped inflict, but it is not irrelevant to weigh her end carefully. If justice is to be respected, it must be carried out with attention. Albert Pierrepoint's notes emphasize timing and detail. A humane method does not absolve, but it announces the state's refusal to mimic the cruelty it punishes. Those notes sit today in archives that also hold photographs from Belsen and Birkenau and affidavits bearing the signatures of women who would rather have used their hands to hold children than pens to sign painful truths. Bringing those artifacts into the same room allows us to recognize the point of the enterprise. Justice cannot resuscitate. It can prevent forgetting from pretending to be forgiveness. When historians teach this case, they usually ask students to read a survivor account beside an extract from the verdict. The exercise is not meant to humiliate the student into silence. It is meant to teach fluency. The language of pain and the language of law must be translators for each other. In the Belsen trial, they were. Witnesses spoke, and the court listened not for poetry, but for proof. The judges spoke, and the world listened not for vengeance, but for standards. Between the two, a space opened where a person like Irma Grese could stand and be seen as exactly what she was. A functionary who chose cruelty with initiative, a beneficiary of a system that rewarded that choice, and a defendant who learned too late that systems die and choices do not. The Allied choice to prefer trials to shortcuts has also been misunderstood as weakness. It was a wager that transparency can inoculate the future more effectively than a rumor can. Rumors bend, transcripts endure. Rumors make martyrs, verdicts make archives. The war had offered sufficient shortcuts to last a century. The peace required a different muscle. Lüneburg flexed it, and the muscle held. It held against the desire to scream, against the desire to simplify, against the cheap cynicism that always asks whether law is enough. Law is not enough. But it is the table on which other good things can be placed without falling to the floor. If there is a single sentence that can carry the weight of this narrative without breaking, it is this. Irma Grese flaunted power that was borrowed, and when the lenders fled, the law repossessed it. She did not fall because an assassin found her. She did not disappear into the fog of a retreat. She was identified, arrested, charged, tried, convicted, and executed. Each of those verbs is public. Each teaches someone watching that impunity can be made to surrender in daylight. That is the opposite of terror, which always prefers night. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority. between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures. There is a last lesson the Belsen courtroom teaches when the bench is empty and the lights go dim. Justice is administrative genius applied to morality. It is calendars and stenographers and rules of evidence in the service of a truth that would otherwise dissolve into shock. The camp dissolved people. The court assembled facts. Between those two verbs lies the difference between power and authority, between fear and law. The young woman who once walked a compound as if it belonged to her discovered that names, not swagger, decide what endures.